Welcome to another episode of Judge for Yourself. Government has come under fire recently for hiring white advocates to fight its legal battles. Speaker of the National Assembly, Baleka Mbete, was most recently criticised for hiring white senior counsel to defend Parliament in two cases. In this case, I think it was Jeremy Gauntlet SC. Advocates for transformation argue that the state should be promoting transformation by appointing black advocates. There is a really important issue here because the really broad issue is the transformation of the legal profession. Of course, once you start debating that, in turn it raises questions about the bench, because obviously the more experience that people gain at the bar, particularly in intricate commercial and other matters, so is the bench enriched. And so the whole issue is intertwined, the entire legal system and the judiciary as a whole inextricably linked to this particular debate. Now, to join this debate on Twitter, please use the hashtag #JFYBlackLawyers. To discuss this, we're joined by the Justice Minister Michael Masuta, Dumisa Ntsebeza, Chairperson of Advocates for Transformation in Cape Town, by Paul Hoffman from the Institute of Accountability in South Africa. Let me start with you. You were quite vocal because you've written quite a bit about this.
Yes.
You don't like what they were doing.
Well, the minister knows that I've always been harping on this thing. My point of departure is that by any analysis, government is the largest consumer of all services. Architectural, legal, auditing, they are the largest consumer of all services. And therefore we say, if there was a deliberate plan to brief black practitioners, not just black advocates, black practitioners, because we do find government work going to the big law firms, you know, the so-called Big Five. If government had a policy, a deliberate policy, no apology, that as part of our empowerment process, we are going to make sure that all black practitioners get work, then we would have been a long distance towards having a pool, because that is what we must grow. We must grow a pool. Otherwise, the pool is going to dry up.
You talk pool for the
pool of
for promotion of the judiciary.
That is the ultimate objective.
Okay. Well, Minister, there's always a lot of criticism about appointments, in particular in the area of commercial expertise. And one of the reasons why that is because we all know that during the apartheid period, very few black practitioners, correct me if I'm wrong, but black practitioners were briefed in these issues. So suddenly you now have got to develop a judiciary which is demographically representative, and you've got problems. And what I think Mr. Ntsebeza is saying is that this is something we should have been a long way to solving. And your department or government, since you're representing them, actually has a role here, a big role, and he thinks you're failing.
Well, good afternoon. Sorry, evening.
Doesn't matter. It'll be shown quite a lot.
And to the viewers, we're going to in and out of meetings all the way. But I just wanted to start by saying that there is a fact which is correctly stated by Advocate Ntsebeza, but which does need to be put in proper perspective. Yes, if you look at government as a single client, then you would say government is the biggest single consumer of goods and services. But if you look at government as a sector and you look at the broader economy, you would say that actually government does not contribute to the larger portion of GDP. I mean, naturally, your GDP, I mean, government gets its resources from taxes, which constitute maybe a third or so of GDP, which then translates into saying that the bulk of the economy is in the hands of private sector. Now, that then translates into saying that sector versus sector, the private sector is a much larger consumer of goods and services than the public sector.
That surely doesn't exonerate you from his problem.
No, I accept that. But I just wanted to
put
that perspective.
All right.
And it is an important perspective. It's an important perspective because firstly, if you look at the bulk of commercial work specifically, which is the real bone of contention, you would find that the bulk of it, even bigger in proportion, lies in the hands of the private sector. Now, certainly as government we have an obligation, and in fulfillment of that obligation, for example, as the Department of Justice, we, in terms of the audited statistics, we have far exceeded the 75% target of work going into historically disadvantaged practitioners. Those are the audited facts. But having said that, and allow me, since I came into office, started interrogating that fact to say, but is this a true reflection? And I suspect that it's not quite, and the reason would be, not all government work goes through the State Attorney's Office. And the stats that we're talking about are stats of work that has gone through that office. The parastatals, which constitute a significant proportion of the public sector,
They do their own briefing.
do their own thing.
Okay, fair enough,
Right?
I got you.
So in a sense, when you start unpacking the issue, that's when you begin to realize that there are other underlying issues that need to be resolved.
All right, I'm going to give it a chance, but I need to ask, Paul, what's your take on this? I mean, at the end of the day, we are looking towards, as Dumisa Ntsebeza said, a representative judiciary which has the requisite expertise. Can't have that if people are denied vast swathes of work.
People must be properly qualified for those vast swathes of work, and Dumisa's complaints are that too many white silks are being engaged by the government in order to litigate matters. Now, this is really a matter of public procurement. When services are procured by the government, they have to be procured in terms of Section 217 of the Constitution, which means according to a system that is competitive and cost-effective. It's certainly not cost-effective to choose for yourself an advocate who you have no confidence will win the case for you. The trouble about litigation is that it's a competitive enterprise. There's conflict going on, and you're looking to win the case. You're not looking to try out untried counsel. That happens in the ranks of juniors, and it happens further down the food chain. The real answer is that there are, the pool, as Dumisa calls it, has too many white participants in it and too few blacks. And that is because of the way that the education system is working. And I'm not talking only about tertiary education, I'm talking about primary and secondary education. If our education system was producing larger numbers of black candidates for LLBs at law faculties in our universities, then we wouldn't be sitting here now debating this problem. The procurement requirements of the Constitution could quite easily be met.
All right, I got you.
Without
I got
complaints
you. I
that
got
too
you.
much work has been
I'm
given
going to
to
give
the-
everybody an opportunity to
the
respond
big-
to that.
big part
Thank
of the
you.
pool.
I'm going to give people an opportunity to respond, but I've got to take a break first.